for convening this important committee. I know that the prosecutors across the state, as well as the citizens of Georgia, are greatly concerned about public safety. In particular, as a result of the recent Supreme Court ruling in Elliott v. State, we all together, the Solicitor Generals in the state, do have great concern about the status of the law, and so we're appreciative of you calling us together and inquiring further of us as to how we think we can work together to better protect the public. Mr. Chisholm of Athens, Clarke County, has already offered some information, and I'd like to defer to him initially, if I may.
Thank you. Mr. Chisholm.
Thank you. When we spoke on Friday, we did talk about the Elliott decision, and essentially the two things that we believe it impacts. Obviously, it impacts the admissibility of refusal evidence at trial, and it also calls into question any testing for breath in light of the what the Supreme Court has deemed to be unconstitutional language regarding the admissibility of breath tests at trial. So not only do we not have the breath tests, refusals admissible, but the breath tests themselves look to also be admissible, and it would certainly be dangerous at this point for us to pursue breath testing in light of the language of our current implied consent language. So the solicitors are proposing a fix to that language that would include not mentioning breath testing as part of refusals, but leaving breath tests in the implied consent language. The reason why we still want to leave it in is that there would be some jurisdictions that would still use breath testing. They simply would not be able to use the refusal of the breath testing at trial. Blood testing will be something that a number of jurisdictions, including Athens, Clarke County, will pursue, but not every jurisdiction is going to be able to pursue blood testing. And so we're going to have to allow for breath testing in some jurisdictions. And so that's what it allows, the proposed new implied consent language allows for. The refusal to take the state-administered test under the new language that's proposed would only would single out blood and urine, and that's what we would pursue. Based on the language of the Waters case back last year, as well as the express language in the Elliott opinion, we believe that it is completely permissible for us to continue pursuing blood testing as well as urine testing, and that the refusal of those tests would be admissible at trial. So that's the proposed fix that we have. There has been support for this from the Governor's Office of Highway Safety, the GBI, also GSP, the Chiefs Association, and the Governor's staff is aware of our language and the need for the fix, and they're also aware of the support we have.
So just so I'm clear, if a refusal of the breath sample occurred, then the suspect, the person, could then be told then a urine or blood test is going to be utilized, and then if that refusal occurred, then it would be admissible in court.
So if a person is asked for a breath test and that person refused to take the breath test, that breath test refusal would not be admissible at trial. The officer would have the option, if they have the resources for their jurisdiction, they would have the option to read for blood or urine if they so choose. Blood is typically the more preferred substance. It provides more information than what a urine sample does. So that officer could then reread for blood if they chose to do so and ask for a blood test. If the person refused the blood test, that refusal would be admissible at trial, but not the breath test refusal.
There'd be a second reading under this hypothetical.
Correct.
Under this, okay.
Yes, sir.
All right, Mr. Gamage, anything that you want to add?
I think Representative Efstration, just to stress, as I know you already are aware, as are our citizens, how very important and critical it is for us to protect as best we can the roads from those who are impaired. And if there's anything else for me to say, it is to say that we're looking forward to working with you all to find a solution that balances, frankly, the citizens' right to privacy and right to Fifth Amendment protections and the state's critical need to keep our roads safe.
Well, thank you for that. I think that balance is what we're certainly striving for here. And I thank both of you, Mr. Gamage, Mr. Chisholm, for your work and your willingness to appear today and provide information. And going forward, I know members of the committee, particularly after they watch the testimony today, they might have questions or be seeking some follow-up. If it would be all right for them to contact you, we would really appreciate that. So,
Yes, sir.
Thank you. I know Ms. Woodard is here as well. Ms. Woodard, would you be willing to come forward maybe to mic 2 right there? All right, thank you.
Good afternoon. I think that my fellow Solicitor Generals have stated the Solicitor General Association as well as the law enforcement executives' discussions and positions that are around this. The only thing that I would say that is incredibly important is that we thread the needle before crossover day in an attempt to get an implied consent that's a legally valid warning for law enforcement to deal with for the pendency of this year. Then we are incredibly in favor of a study group going forward to look at potentially rewriting implied consent in some of the DUI statutes as a total because of a difference in federal requirements that may be present now that would allow us to step away from some of the administrative issues that have been implied with the implied consent in administrative positions in total. So it's imperative that we get something right now. The warning that the officers have is invalid as to all of the testing. That's the holding of Elliott, means that the pure language of that warning is no longer valid because it contains misinformation. So that's what's important to thread before the end of this session so that we have a valid reading for the officers for the pendency, and then a deeper look at some of the other conflicting issues that we realize are present in the deeper look at the administrative suspension aspect.
Thank you, Ms. Woodard. Any questions for any of our witnesses from the Solicitors Council? All right, hearing none. Thank you very much. If you all wouldn't mind stepping back. I know that we have several of our friends from the defense bar that are here today, and Mr. Rick Reisig is present. Mr. Reisig, if you could come forward to microphone 1 here, your left.
Good afternoon.
Thank you. If you just introduce yourself and then proceed with any testimony that you have.
Good afternoon. My name is Rick Reisig. I'm a RYCZEK. I'm a criminal defense attorney in Lawrenceville, Gwinnett County, Georgia. I agree that the Elliott case has changed the DUI. It's going to change the DUI practice from a criminal defense perspective. It's going to change the way cases are prosecuted. The very easy answer to what the Elliott case has done, and I'm sure you've already heard, is that refusals are out. I think it remains to be seen whether, I think it's going to be clear, and I think most of the prosecutors will agree that it affects breath testing. It remains to be seen whether it's, and to what extent it's going to affect blood testing and urine testing. I think it's going to be very difficult to thread the needle that Ms. Woodard has discussed. There are Miranda implications now that the Olivet case, which came out in October of 2017, recognized that we have a right that breath testing and chemical testing to some degree, all kinds of chemical testing to some degree, implicates our right against self-incrimination. So there are additional considerations to think about when enacting or when passing a new implied consent statute.
Mr. Reisig, do you have any thoughts about potential solutions that would allow for what I'm contemplating possibly is that the person under investigation is as part of the advisement is made aware that there might be some benefit associated with providing the sample. Do you see that as potentially problematic for a benefit in exchange for the action?
And I'm sorry to interrupt you, but if you're asking if we should advise a motorist that there's that they might benefit in some way by providing a breath sample.
That's right. Yeah.
I think that would, once somebody's under arrest, if you provide any hope of benefit, that is not likely to be admissible if you do provide some sort of hope of benefit. Now, and I would always argue to judges when before this Elliott case was decided, is there are two buckets. One bucket implicates a right against self-incrimination. That includes making a statement after you've been under arrest. Trying on a glove, something like that, where you do an affirmative act. That implicates under our Constitution self-incrimination. The other bucket is submitting to an act, like a buccal swab. If you were to take a fingerprint, a swab of your DNA from the inside of your mouth, you're just submitting to an act. If you are performing an affirmative act, and that's pretty clear now, according to the Elliott case, that implicates our right against self-incrimination. If we do that, if we give somebody any hope of benefit in order to incriminate themselves, that's likely to be, or I would expect it to be, a pretty hard line, black and white rule, would not be admissible. So if there's any language in the implied consent saying you're going to get something by breathing into the machine, I think it's not likely to be held as constitutional.
Any questions from members of the committee? All right. Thank you, Mr. Reisig, for your testimony. Thank you very much. All right. Is Mr. Giudice present? I understand Ms. Travis is available from Gactyl. Ms. Travis, would you like to come forward to microphone?
Brought somebody that's more
very good.
expertise. Yes, this is Scott Key.
Wonderful.
And I'll let
Yes.
him introduce himself to the committee.
Thank you.
Hey, good afternoon. I am Scott Key, the immediate past president of the Georgia Association of Criminal Defense Attorneys. I was also the amicus attorney. I wrote and submitted the friend of the court brief on behalf of GACDL at the request of the Supreme Court. The Supreme Court, in addition to seeing briefs of the parties in Elliott, also solicited briefs from GACDL, from PAC, and from the Solicitor General's office. And though in footnote 1 of the opinion in Elliott, the court comments that the amicus briefs played a pretty big role in how the case came out. A couple of comments, and I think what I understand the task or the assignment to be is to comment on possible changes to implied consent. Just a couple of comments on implied consent as it presently stands. While right now the Elliott decision is limited to breath tests or the admissibility of the refusal to submit a breath sample, there is litigation in the Supreme Court right now that may have a bearing on blood and urine. There's a case called Licata, L-I-C-A-T-A, that's pending now. It's possible that even with the efforts to amend and revise implied consent, it could be that there's the potential that the card would become obsolete before there's another session. One possibility to make an implied consent card that would withstand all of that would be if there are really two things that come up in implied consent, and one is the consequence of refusal to your driver's license that starts an administrative process. The other is the admissibility of the refusal in court in the criminal case. In terms of the criminal case, it may be that that you're going to see a holding in subsequent litigation that extends the Elliott holding to other types of chemical tests. One possible way to draft an implied consent card that would withstand that would be to simply just advise suspects that their refusal may be admissible instead of will be admissible. And the reality is, even if the testing or if blood and urine survives litigation that's currently pending, there are all sorts of things that can happen in pretrial motions that may lead a refusal to be inadmissible, even if we'd never had the Elliott decision. I think to say that the refusal may be admissible is a more accurate statement of the reality of what can happen as a criminal case unfolds. I think the language of may would also be important in terms of the administrative process. If you refuse a test, breath, blood, or urine, you can have up to a 1-year suspension, but the reality is that if you win the criminal case, either by acquittal, a plea to a lesser charge, or dismissal of the criminal case, the successful resolution of that case for defense counsel or for the defendant means that the suspension is reversed. So I don't think it's an accurate statement that your license will be suspended upon refusal, because depending upon how the criminal case unfolds, it may be the case. I heard a moment ago, and I might have misheard, that there's a possible proposal that in the event of a refusal, that there would then be a second reading that asks for a different type of test. One of the concerns I would have with the possibility of two different readings of two different implied consent cards is that can set up an incredibly confusing moment both for the driver and the officer. If the implied consent card can be hard to comprehend, and what I've seen in past cases will lead to the suppression of test results or refusals has been where the motorist doesn't understand. The motorist then asks the officer, "I don't understand what you're telling me," and then the discussion back and forth, the officer gets it wrong or says something that's improper, and completely without the intent to mislead, but trying to be helpful. I've seen suppression. I've seen evidence be suppressed just from that give and take, just from that subsequent conversation. I think if you set up a situation where you're going to have one card, and then depending upon what the answer is, you then read a second card, I think it creates a level of confusion both for the motorist and for the officer. In terms of the question that was put to Mr. Reisig a moment ago about advising someone of the potential benefits, it does create a situation. There's a statute that says that if you induce a statement with a hope of benefit or fear of punishment, that renders and the statement renders is what creates the statement. It renders that statement inadmissible. I think it also puts the officer in a situation where, based upon the language he's reading to the suspect, he's giving legal advice, and so I think that would be a concern that I would have. So those are my thoughts on ways to potentially revise implied consent so that it could potentially withstand litigation that's currently pending. And I'm happy to answer any questions that the committee might have.
Any questions? Yes, sir.
Just want to make sure I'm getting you right. You're saying your advice is that the statement is, in terms of a blood or urine-based test, that it may be used against you in court. You feel like that subsequent rulings would capture possible add-ons to that.
It would, because you're saying may, so there's some conditions
Yeah.
that are in place if you use the language of may.
So that would clarify the uncertainty with the Licata case.
It would, yes.
Thanks.
Not only the Licata case, but subsequent things that may happen as the case makes its way through the court system. The refusal can be suppressed, and could have been suppressed even before Elliott, just based upon things that might have unfolded and rulings by the court that might render that refusal inadmissible.
Follow-up question.
Yes, please.
So your advice would not be to strike out at this time blood or urine based on the implied consent card. It is to modify, to leave that flexibility.
You
to
could really
what
do it
happens.
either way. You could eliminate. You could just not even talk about admissibility in court. You could just leave that subject off the card in its entirety, and that would be a safe approach. But if that's something that you want to maintain in the language of the implied consent card, I think if you want to leave that theme in there, if you substitute shall or will to may, I think it puts you on safer ground.
Representative McLaren.
Thank you, Mr. Chairman. Just off the bat, my concern with may is that it's ambiguous, could be used to mean or interpreted to mean somebody has the right to use this, and then it's up to their discretion whether they choose to do it as legally that they have the right. But yeah, so would it be too cumbersome in your estimation to say something like possibly could be? I mean, I know there's at some point you go down this road of just adding a bunch of qualifiers, but again, I wonder if there's a clearer way to express what the sentiment you just expressed, which is who knows what happens in litigation. The reason why it's uncertain is because there are lots of variables in litigation, and that it's not just a question about the legality of blood and urine testing.
I think if you put language in there, and I appreciate that. I appreciate that concern. I think if you start putting in language like possibly could be. I think the problem with words like that is you're not really stating a percentage, but I think you're getting into what is the likelihood, and possibly could be suggests maybe it's a less or more likelihood, whereas maybe it could go either way, potentially.
And if you had to, this is kind of putting you on the spot, sorry. If you could, but you're already there. If you could just sort of speak to what you think the public safety purpose of that line in the implied consent statute or card is. I mean, it would be good maybe to reflect on, why is it that we want the defendant to know that it might be admissible, right?
I think that I think it could be that it could be perfectly arguable that you shouldn't include language like that because it's not for the officer to comment upon what might happen in the criminal case. From the perspective of the motorist, I suppose it's like it echoes somewhat the Miranda language, what you say can and will be. Well, they say can and will be. I suppose that if you let the suspect know that there's the possibility that your refusal may be one day used against you in court, it maybe heightens their knowledge of the importance of that decision they're about to make. I think the argument could also be made that if you're telling someone that language is telling them that their refusal is going to be used against them is potentially coercive.
I'm gonna at this time. I'm gonna ask. I see Mr. Judiciary just came in. If he'd be willing to come forward to microphone 2 over here, would like to have him involved in the conversation. And sir, if you wouldn't mind just holding tight where you are, then the members can ask questions as they come. But here, it's at the end of this table here.
I've been in court. I apologize for running a few minutes.
If you just introduce yourself, please.
Yes, sir. I'm Ray Judiciary. I'm a criminal defense lawyer. I've been practicing law since 1985 and started as a misdemeanor DUI prosecutor in DeKalb County, and I've been doing criminal defense work ever since.
Well, thank you very much for being here today. Of course, the discussion we're having is about the Elliott case, and this is our second of what will probably be several hearings on possible legislation for this General Assembly. I have to present one of my bills in the Judiciary Civil Committee right now, so I'm going to step out and ask Chairwoman Ballinger to chair the rest of the meeting here today to allow the members to ask questions. So thank you all for being here. The full Judiciary Non Civil Committee meeting will meet tomorrow morning at 8 a.m. So, thank you. Yeah. Yeah. Thank you.
Thank you. I do apologize. So, members, y'all are going to have to tell me your numbers. Who is Mike 7? Okay. Chairlady Silcox, you had a question?
Yes, I guess I hear what you're saying, Mr. Key, about using the word may, but I think a lot of this also would go to the intonation of someone's voice. May or may. I mean, seriously, because it lacks certainty to me. It doesn't really provide adequate notice of the importance of the words that they're going to use following that their reaction. So to me, I think may is kind of more slippery legally than shall.
The problem with shall is it's not an accurate statement of
Right.
the state of affairs at the time.
I understand.
There is no guarantee that your license will be suspended upon refusal. If the refusal or whatever other facts in the case might develop lead to the case being dismissed, a plea to a lesser charge, or an acquittal, then the reality is that the driver's license suspension is lifted at that point in time. So if you say will, that's not an accurate statement.
Right.
If you say that it will be admissible against you in your criminal case, again, that's not an accurate statement. One, because the other forms of chemical testing are subject to litigation right now.
Exactly.
And there could be things that unfold in the way the criminal case was investigated that could lead to its suppression. So the use of the word will is not an accurate statement of reality at that moment.
Right. Just a tough one.
Any follow-up, Chair? Okay. Representative, you had a question?
Yeah, Mike, and this can be for both, if able. My concern with taking the entire statement out, as you said, as was an option, is it not an individual that's under this? Is it not? Do they not have the proper? Wouldn't we want to inform them that it can be used against them legally? If I'm correct, they can still use blood or urine. At this point, we don't know what litigation is, but wouldn't it be upon us to encourage that understanding, as stated, to know the importance of that decision instead of them saying no and being surprised that that's being utilized against them? Don't we have some kind of obligation to inform them at the time of that decision being made?
That it's probably more problematic than saying may, and so I think I'd tend to agree. But in terms of just possible ways to not give incorrect information to motorists, one possibility is just to not say anything about it. The other possibility is to just strike the shall or will and substitute a may. Of course, there are all sorts of things that can happen to you when you're under investigation that can later be admissible. There's a whole host of things that could come up that will subsequently be admissible against you in court. That if you were to try to go into that, it's almost you couldn't reach an exhaustive list.
Thank you. Any follow-up? Oh, okay. Representative McLaren?
I apologize, Mr. Chair Lady. I think it's on an error.
Oh.
Yeah.
Okay. Apparently you were able to solve all the questions of the committee just by your mere presence. So
That's not the first time.
Yeah. Ladies and gentlemen of the committee, do you have any additional question on this issue? Hearing none, I believe this was all on the agenda for today. So otherwise, the full committee of Judicial Non Civil is hereby adjourned. Thank you.